application and appeal to follow in Swift and Carpenter.
Yes, Mr. Sweeting.
Lords, my lady, good morning. I appear for the appellant in this matter together with my learned friend Mr. Army. The respondent is represented by my learned friends Mr. Audland and Mr. Viney, and the Personal Injury Bar Association, often shortened to PIBA, by my learned friend Mr. Allen.
Yes.
Lords, there are two applications before you. Firstly, to adduce further evidence on the part of the appellant. Your lordships have, your lady, had seen the short skeletons for that, and the agreement subject to the court's approval is that that evidence should be before the court for the purpose of the appeal, and that any argument about it should be deferred until the close of the more substantive.
Well, I wonder about that, but that's what the position the parties have reached,
Yes.
is it? And the other application is for...
Is by the Personal Injury Bar Association to intervene,
Yes, of course.
which isn't opposed.
Well, that's not opposed, and Lady Justice Nicola Davies and I agree it. My Lord thinks it appropriate for him to be neutral on the matter because he is the president of the association. But since it's opposed, since it's unopposed, that's hardly controversial. Now, can I just explore a bit further the question about the application to adduce further evidence?
Yes.
I'm sorry I hadn't picked up that, perhaps it wasn't said anywhere, but that the agreement is that the evidence should be before us. Is that effectively de bene esse?
It is, and those are precisely the terms which are used in my learned friend Mr. Audland's skeleton on the point, at the conclusion of his skeleton.
Yes, but I seem to see in that skeleton a suggestion that one of the reasons why they were formally opposing the application was that it was their position that it was, if the evidence were to be admitted, they would wish at least to consider, I thought rather more than that, adducing their own evidence in response. I'm right about that, aren't I? Am I right about that, Mr. Audland?
Yes, my lord, one of the grounds is that had evidence been adduced at trial, then inevitably the respondent would have adduced not only the sort of evidence that's now being sought to be adduced, but also expert evidence.
Well, that's very much what I thought. And we've had a discussion about this, and we've reached what are very provisional views. We don't want to unsettle a settled position between counsel, but I'm not quite sure from what I've heard that we would be doing that. Nor in any event do we want to express any final view, because we haven't yet heard argument. But our provisional view is this, that it would be very unsatisfactory to seek to determine the issues relating to what I might call the PPO route without adducing the supporting, without seeing the supporting evidence, and without the opportunity for evidence in response. Certainly the latter element would mean that if we were going to consider the PPO, there would have to be an adjournment so that there were full evidence from both sides before the court. In normal circumstances, the appellant would face an uphill struggle in any application for an adjournment at this stage. But we might be receptive to such an application in the unusual circumstances of this case, both because it would cause difficulties in this case itself, for the court having to arrive at the right answer in a genuinely difficult situation with one of the alternatives that has been argued for, either on an extreme view, if we weren't to admit the appellant's evidence, not being available at all, or being not fully developed. But another reason would be because of the wider implications of this case. If there were to be an adjournment, the court, I think, would welcome, I say I think, the court I know, would welcome a fuller review of all the possible alternatives rather than those for which the parties themselves are contending. PIBA, in its, if I may say so, very helpful written submissions, has opened up some doors, but they may need to be opened a bit wider. So the upshot of all that is that if the parties agreed or one party sought an application for an adjournment, we might be receptive. We'd have to hear argument about it if it were opposed, but we might be receptive. We could, I am reasonably confident, well, never 100% confident in matters of listing, but the things are much better in the Court of Appeal than they have been in past years. Be reasonably confident we could get the case back on in the Michaelmas term for the same constitution with the same 2-day listing. Probably the parties wouldn't want it at the very beginning of the Michaelmas term, because getting their case in order might be a bit tricky with the break and so on, but certainly in the Michaelmas term. Clearly, there might be cross consequences as regards the costs of the adjournment itself. Again, we don't express a definitive view about that, but that's just stating the obvious, because the situation is being brought about by the late application to adduce further evidence. Well, not late application, but the application in the proceedings to adduce further evidence. But we thought at the very beginning of the hearing we should put that provisional view of ours before you. You may, I think you will, want some time to consider it both with your clients and with each other. And subject to anything you want to say now, we might rise for, I hope not that long, but as long as you reasonably need, to see whether this is a route that either everyone wants to go down or that one party wants to press for, even though the other opposes it. Yes. Anything that either of my... if we go down this route, we may have a further discussion about the kinds of areas that it would be helpful to explore. This is, on either side of me, the dream team so far as the constitution of this court is concerned. Both my lord and my lady are very familiar with this area, and it might be helpful to have an informal discussion of points that are worth considering. All subject to any points people may want to take about points not taken and so forth. But if the point of the adjournment is to have a full consideration of all issues, that may be a helpful thing to do. But let's wait and see whether this course commends itself to parties.
Lord, may I just raise one point?
Yes.
Before having a discussion in open court, which is that whilst the very helpful indication relates specifically to the PPO, it's our position that the problematical situation of the absence of evidence at trial relates to both limbs of the appeal, because essentially what the appellant is seeking to do is to now adduce evidence of costs of borrowing to challenge Roberts and Johnson generally by showing that the costs of the borrowing exceed the lump sum and therefore the lump sum is the only.
Perhaps I haven't read the papers carefully enough. There isn't a formal application in that regard, is there? Or is there? I know one of your points made is that evidence about costs of borrowing below was slightly sort of introduced by saying we've seen it on the internet and it's no better now. But is there actually an application to adduce formal evidence about costs of borrowing?
Well,
or are we in the same position as you say we were?
The evidence such as it is, we say is inadequate, but that same evidence is evidence of an offer or an illustrative offer of a mortgage.
Oh, I see
hence
what you mean.
The costs of borrowing.
Oh, I was being slow.
On the platform of that evidence, the appellant seeks to persuade you that Roberts and Johnson itself, not only as a PPO option, but its case should be overturned because of the costs of borrowing that flow from that evidence.
Yes. Well, resist the temptation, Mr. Ortland, to develop your substantive submissions.
Certainly, but
But the point you're making is that if we were to adjourn for further evidence, without prejudice to, well, I'm not quite sure what point you're making. I won't make it for you, but everyone's heard what you've said.
It is simply this, my lord, that the concerns that your lordships have over the absence of evidence and the need for further evidence impacts, we say, just as much on the Roberts and Johnson lump sum issue as it does on the PPO, because both arguments hinge upon the costs of borrowing, and it is the absence of evidence as to the costs of borrowing at trial that have led to the situation in which we find ourselves.
Well, one consequence of that might be that if there were an adjournment, the appellants or the respondents might wish to add to the evidence that's already been sought to be adduced, ostensibly for a different purpose, to address that point head on.
Certainly.
Very well. Well, I see the point. I'd make no comment about it. Okay.
Well, I don't want to get into the substantive argument,
No,
but the point your lordship has just alluded to is the one I was going to ask for some clarification about, and it may be you've just given it, but if there were to be an adjournment, on which I'll obviously need to take instructions or an application for that, then I think the position would almost certainly be that we would wish to do more than have simply a mortgage illustration.
I think let's not go too far down that route now. You're sensible to flag that up. If we decide to go down